Hand in hand is how Darryl George and his mom Darisha left the Anahuac courthouse. A look of defeat across their faces, a hoodie covering the locks at the center of Thursday's bench trial. They didn't speak to the press this time, but just before the hearing started, the 18-year-old high school junior told reporters this whole ordeal has been sad.
It means a lot to me. It's my roots, you know. It's how I feel closer to my people, how I feel closer to my ancestors.
Now those feelings are even more amplified after a judge ruled that the Barbers Hill ISD policy that's kept him out of the classroom for months doesn't violate Texas's Crown Act. And if he wants to go back to school, he'll have to cut his locks.
Well, they were in tears. I mean, I felt for her. And I was strong when I was with them, but it's painful.
It was an emotional outcome for State Rep Ronald Reynolds, too, who was the main witness at the hearing and co-sponsored that bill.
He came here optimistic, and he left here dejected with that the legal system had failed him. And he said, all because of hair.
The Texas Crown Act states any student dress or grooming policy adopted by a school district may not discriminate against a hair texture or protective hairstyle commonly associated with race, including braids, locks, and twist. At the center of this case is whether that covers length, too.
Honestly, we thought it was understood. We thought it was like, okay, there's no misinterpretation, no ambiguity by the fact that if you have braids, locks, or twists, that you're going to have a certain length of hair in order to wear those natural hairstyles.
But the judge ruled that's not the case because the law does not explicitly reference length. And therefore, Barbers Hill's grooming policy that male students cannot have hair that extends below the eyebrows, below the earlobes, or below the top of a t-shirt collar is not unlawful. After the ruling, Barbers Hill ISD Superintendent Dr. Greg Poole sent us this statement saying, quote, the U.S. Supreme Court recently ruled that affirmative action is a violation of the 14th Amendment, and we believe the same reasoning will eventually be applied to the Crown Act.
Now, after the ruling, the judge suggested that lawmakers clarify the Crown Act to include length. The issue with that is that the Texas legislature only goes into session every 2 years, which would mean that if the Crown Act was amended and those amendments were adopted, it wouldn't go into law until September of 2025. Far too late for Darryl George. His attorneys say they do not plan to wait on that. They say he is not cutting his hair and that they do plan to appeal today's decision. In Anahuac, I'm Janelle Fort.